Blake Lively stormed out of the Justin Baldoni settlement talks? And Bryan Freedman saying we're going to trial?
The moment the courthouse doors opened and cameras caught that split-second contrast between composure and confidence, the narrative shifted from quiet negotiation to full-scale legal warfare. Because what unfolded was not simply another celebrity settlement meeting, but the kind of high-stakes showdown that threatens reputations, careers, and carefully curated Hollywood images. And when one side walks out appearing visibly strained while the other side emerges smiling, laughing, and openly welcoming trial, the story stops being about mediation and starts becoming about survival. That single line ignited the firestorm, because whether she truly stormed out or simply exited without a smile becomes irrelevant once the optics settle in the public imagination. And in celebrity legal battles, optics are everything, because perception moves faster than fact in body language, speaks louder than press releases. And what viewers saw in that courthouse footage was not the glow of someone who had just secured a quiet resolution, but the tension of someone who had just endured 6 grueling hours of confrontation behind closed doors. This was never going to be a friendly mediation, because when two high-profile names like Blake Lively and Justin Baldoni find themselves locked in legal tension, the stakes extend beyond paperwork and into personal brand territory, into public sympathy, into industry alliances, and into the court of public opinion, which often proves harsher than any judge sitting behind a bench. The cameras followed every step, every glance, every subtle expression as reporters called out questions that hung unanswered in the air. And silence can sometimes be louder than denial, especially when that silence follows a closed-door session described as intense and relentless.
Not as confident there. Not as confident, if you ask me, as she's walking out. Not as confident as this man who's walking out smiling.
That comparison became the gasoline poured onto an already smoldering situation, because when one side exits appearing measured yet visibly serious, and the other side appears relaxed and even cheerful, speculation writes itself, and gossip does not require confirmation when it has visual contrast to dissect frame by frame. The mediation itself was reportedly brutal, the kind of legal environment designed not to comfort but to dismantle confidence, because a magistrate judge's job during settlement talks is not to reassure but to challenge, not to validate but to expose weaknesses, and that means both parties are confronted with worst-case scenarios, legal vulnerabilities, and the possibility that their narrative may not land the way they expect once placed before a jury. Imagine walking into that room believing you hold the stronger case, believing you possess moral leverage, believing public sentiment leans in your favor, only to hear a neutral authority dissect every assumption and highlight every potential flaw in front of your legal team, because mediation strips away illusion and forces each side to confront reality without applause or curated headlines. And when those doors finally open after hours of legal sparring, the way each person carries themselves becomes the unspoken summary of what may have transpired inside, because people do not leave high-pressure confrontations unchanged, and subtle shifts in posture and expression often reveal more than carefully crafted statements. There were no grand declarations from Blake Lively, no confident one-liners, no dismissive smirks directed toward the cameras, only a composed but unmistakably serious departure that immediately triggered whispers about whether the mediation exposed vulnerabilities she may not have anticipated. Because the conversation inside that room was not controlled by publicists but by a judge determined to scrutinize both narratives. Meanwhile, the other side did not hesitate to project confidence, and that projection alone changed the temperature of the situation. Because when an attorney steps forward and signals readiness for trial rather than urgency for settlement, it suggests belief in leverage, belief in strategy, belief in endurance.
Didn't reach a settlement today?
No.
So tomorrow.
No settlement reached yet. We'll see.
You think you'll go until Friday?
We'll see.
But there's still a chance for settlement?
There's always a chance.
Is everyone...
There's always a chance for a settlement. Yeah.
The phrase "not today" echoes louder than it appears at first glance, because in celebrity legal conflicts, a failed settlement attempt often signals that one side feels no immediate pressure to compromise, and when there is still always a chance but no clear progress, tension builds rather than dissolves. Settlement is about calculation, about assessing risk, about deciding whether exposure in court is worth the gamble, and if one side believes trial may serve them better than compromise, compromise that belief alone becomes a strategic weapon, because the mere threat of courtroom exposure can shift negotiations dramatically. But the moment that truly electrified observers was not the failed settlement update, but what followed next, because confidence escalated into open anticipation. And anticipation in a legal battle of this magnitude is rarely accidental. Looking forward to trial is not neutral language, and it is certainly not the phrasing of someone fearing public scrutiny, because trial means testimony under oath, cross-examination, evidence disclosure, media frenzy, and relentless narrative breakdown in front of a jury composed not of industry insiders but ordinary individuals evaluating credibility without celebrity filters. When an attorney openly welcomes that environment, it signals something deeper than bravado, because either it is a calculated show of strength designed to intimidate the opposing side into settlement, or it reflects genuine confidence in the legal position being held. And either possibility reshapes the power dynamic entirely. Inside that courthouse, the parties were reportedly kept separate, navigating mediation from different rooms connected only by a judge moving through private hallways. And that physical separation mirrored the emotional and strategic divide that has defined this conflict from the beginning. Because compromise requires convergence, and convergence appeared nowhere in sight. Observers noted serious expressions, limited interaction, measured exits, and none of the visible relief that typically accompanies resolution. And that absence of relief feeds the narrative that what transpired was not mutual agreement but intensified disagreement. The gravity of trial cannot be overstated, because once a case reaches a jury, control evaporates, and narratives crafted behind closed doors are tested in public view, dissected by opposing counsel, analyzed by commentators, and cemented into record. And for a public figure whose image has been meticulously cultivated for years, that exposure carries consequences beyond legal verdicts. Those words hang heavy over the entire situation, because trial does not simply determine legal liability, but shapes legacy. And losing before a jury carries a permanence that quiet settlements never achieve, because verdicts linger, headlines archive, and reputational impact extends far beyond the courtroom. And that is where the tension intensifies, because this is no longer merely about whether mediation succeeds, but about what each side believes they stand to gain or lose if the curtain lifts fully and proceedings move forward into public scrutiny. Confidence versus caution, anticipation versus apprehension, smile versus silence. Those visual contrasts may not tell the full legal story, but they set the emotional stage for what could become one of the most dissected celebrity legal battles in recent memory. The question now is not whether cameras captured a dramatic exit, but whether that exit marked the moment when compromise faded and confrontation solidified. Because once one side signals readiness for battle and the other side appears cornered by the weight of potential exposure, the road ahead narrows into a single, unavoidable direction. And as observers continue to replay footage, analyze expressions, and parse statements for hidden meaning, the real drama may not lie in what was said publicly, but in what was implied between the lines. Because when a lawyer says, "I'm looking forward to it," and settlement remains unresolved, the countdown to something much larger quietly begins. The silence after mediation can sometimes be louder than a courtroom verdict, because when powerful names step out of a closed-door negotiation without resolution, without visible relief, and without a united statement hinting at compromise, what remains is not peace but pressure, and pressure in. Hollywood does not stay contained within courthouse walls. It spills into headlines, into industry whispers, into boardrooms where future casting decisions are made quietly but decisively. What makes this moment combustible is not simply that no settlement was reached, but that one side appears strategically comfortable with escalation. An escalation in a case that touches on harassment allegations, retaliation claims, and credibility disputes means the narrative will not remain theoretical. It will become forensic, dissected under oath, cross-examined line by line, and scrutinized by 12 strangers who have no investment in celebrity branding. When you look at the way this unfolded, the 6-hour mediation was never designed to be gentle, because a magistrate judge's role in such conferences is to strip both parties of illusion, to force them to confront how their case might unravel in trial, to point out inconsistencies inconsistencies, weaknesses, evidentiary gaps, and unpredictable jury reactions, and that kind of blunt assessment can shake even the most confident litigant. If Blake Lively entered that room believing settlement would protect her from prolonged exposure, she would have faced the sobering reality that mediation is not a shield, but a test, because mediators push relentlessly, asking uncomfortable questions, probing strategic assumptions, and presenting scenarios that may feel hostile, but are meant to reveal risk, and risk is what settlement negotiations revolve around. Meanwhile, Justin Baldoni's team, by projecting composure and openness to trial, subtly shifted leverage, because willingness to proceed publicly often forces the opposing side to reconsider their appetite for scrutiny, and scrutiny in a trial setting is not limited to the original claim, but extends to text messages, emails, timelines, prior statements, and any inconsistency that opposing counsel can amplify in front of a jury. What complicates this further is the reality that celebrity cases are never purely legal. They are reputational chess matches, because every filing becomes a news cycle, every statement becomes social media fodder, and every courtroom development influences public perception long before a verdict is delivered. When the cameras caught Justin Baldoni smiling as he exited, that image became symbolic, whether intentionally or not, because in high-stakes disputes, demeanor is interpreted as confidence, and confidence suggests belief in outcome, and belief in outcome implies strategy. The legal battlefield now appears divided between those who think settlement still looms as a rational conclusion and those who believe this confrontation is accelerating toward an inevitable trial, because once a lawyer publicly declares readiness and even anticipation, retreat becomes harder, without signaling weakness. And that transformation from speculation to sworn testimony is what makes this moment pivotal, because the storm outside the courthouse may have been visual, but the storm inside the courtroom could redefine both reputations permanently. The legal chessboard is now visible to the public, pieces advancing slowly but deliberately, and every move signals intention, and intention in high-profile litigation is never accidental. What began as settlement talks has evolved into something far more dramatic, because when one side emerges projecting resilience and even eagerness for trial, and the other side departs without the glow of resolution, the story shifts from quiet negotiation to impending confrontation. The next chapter will determine whether cooler calculations prevail and settlement salvages discretion, or whether the path forward leads directly into a courtroom where narratives are tested under oath and verdicts carry lasting consequence. For now, the footage loops, the statements echo, and the contrast remains etched in public memory, because in celebrity legal battles, perception is often the opening argument long before the first witness takes the stand. And if the lawyer's words hold true, if the anticipation of trial is not merely posturing but preparation, then what unfolded during those 6 hours may only be the beginning of a much larger, far more public reckoning. The question is no longer whether mediation was tense, but whether that tension marks the final attempt at quiet resolution before a courtroom confrontation that neither side can fully control once it begins. And in that uncertainty lies the real drama, because once trial becomes reality, the narrative leaves the hands of publicists and enters the domain of sworn testimony, legal strategy, and jury deliberation, where smiles, silence, and speculation give way to verdict. The storm outside may have sparked headlines, but the storm ahead could determine everything.